Today we're going to talk about the duty to warn in Virginia, particularly for mental health care providers. Many of you are probably familiar with the Supreme Court decision from California that has the name of Tarasoff versus the Regents of the University of California. That was a cutting-edge decision that really changed how everyone in the United States viewed the duty of mental health care providers to protect third parties from patients or others that may be under their care. So let's look a little bit at the details of Tarasoff. Tarasoff, the facts of the case involved a therapist, psychologist, who was treating a young man. The young man said that he was going to murder his fiancée when she returned from South America. The psychologist was convinced that, in fact, the patient had the means to do it and had the intent to do it, and presented a real physical threat to his fiancée, Ms. Tarasoff. He was concerned enough about this to notify the campus police, who detained the gentleman. However, the campus police released him when he said that he was not going to do it. He then reviewed the situation. The therapist then reviewed the situation with his supervisor. The supervisor counseled him that he was wrong in taking that action and that he should remove any reference in his notes to having had that conversation with the patient. Unfortunately, thereafter, the gentleman went out and murdered Ms. Tarasoff when she returned from South America. The Supreme Court of California, for the first time, held that a mental health care provider had a duty to protect a third party. That is, if there was a reasonable threat against an identifiable individual, then the mental health care provider had an obligation to warn or take steps to protect that third party. That was pretty unusual, and it really kind of rocked the world of American health law, creating that third party obligation. That was all well and good until it came to the Supreme Court of Virginia in 1994. In Nassar versus Parker, the Supreme Court of Virginia reviewed very similar facts to what Tarasoff had. And those of us who are healthcare lawyers thought that it was a slam dunk for the plaintiff that the psychiatrist in that case, Dr. Parker, had a obligation to warn or take steps to protect a young woman who had been identified by her boyfriend that he was going to murder her when she came back to town, and that he was a former Marine. He was known to have guns and appeared to have the intent to commit the crime. In March of 1995, the Supreme Court of Virginia said, "You fruits and nuts in California have got it all wrong." The restatement of torts, which you base your opinion on, requires that there be some special relationship between the either between the provider and the patient or between the provider and the third party. That special relationship is more than what a casual individual would have with another member of society. And they held in the Nassar opinion that came out in 1995, we'll come back to 1994 in a second, that in fact there was no special relationship, that any duty was purely that of a private citizen because Dr. Parker had no ability to control the young man. He was a voluntary admission to the psychiatric hospital, so there was no ability to control him in that sense. He was free to discharge himself whenever he wanted to, and therefore there was no duty upon Dr. Parker. That was quite a surprising result for everyone involved in caring for mental health care patients because we had all come to adopt the 1976 decision from Tarasoff. Interestingly enough, the General Assembly of Virginia had actually taken steps in May of 1994 that made the decision in Nassar versus Parker by the Supreme Court of Virginia probably moot anyway. There was a bill introduced in the General Assembly of 1994 that set forth what the obligations of a mental health care provider was to an identifiable third party who was at risk, and that law became, or I'm sorry, that bill became law in May of 1994. So what does the Virginia law have to say? Well, curiously, it looks a whole lot like what the Nassar versus Parker decision was. It is actually a statute that protects mental health care providers far more than it actually protects people who may be at risk because of violent patients. Because if we look at the statute, it says that a mental health service provider, and we'll talk about that definition in a second, has a duty to take precautions to protect third parties from violent behavior or other serious harm only when. And so let's look at the conditions that must be met. We'll look at those conditions in a second after we look at who is a mental health care provider. It's a very broad list. It is intended to be very inclusive. But again, remember that this is a protection statute for behavioral health care providers, not necessarily a statute protecting potential victims. So let's look at what that duty to protect is. What are the conditions that must be met? First, the client has to communicate directly to the provider, orally, in writing, or via sign language. It's not a posting on a Facebook page. It's not a friend who tells the provider. It's not some other gossip that the provider becomes aware of. It's a direct statement by the client to the provider. It is a specific and immediate threat to cause serious bodily injury or death. It is not a vague allusion. It's not a casual, vague threat that's made out there. It's to an identified or readily identifiable person or persons. So it has to be to identifying Sally Joe or a school, maybe a shopping mall. One might argue even a city these days because of the way that society has changed over the years as to the seriousness of these threats. And the provider has to reasonably believe, or should reasonably believe, according to the standards of his profession, that the client has the intent and ability to carry out the threat. So if you have a quadriplegic patient who is saying he's going to go strangle his nurse, that's probably not something that is a threat that meets this threshold. And last but not least, it has to be an immediate or imminent threat. Again, there's no definition as to what that is, but it is not just sort of a vague manana sort of allegation. It has to be something that clearly is pressing on the client's brain. So if those criteria are met, what is it that a provider has to do to comply with the statute and, in essence, receive immunity for their conduct? Well, first of all, if you are a peer recovery specialist or some other unlicensed technician in a behavioral health care setting, you've met your burden if you report that to your immediate licensed supervisor. So whether, maybe to a LCSW, maybe to a psychologist, some other licensed practitioner in that clinic. But then we turn to what does a licensed provider have to do in order to discharge their duty. First is seek involuntary admission. Doesn't have to mean that they have to be successful, but if they at least start the process of a TDO admission and the evaluation towards an involuntary admission, they've met their burden. The second is they notify the potential victim, or if it is a child, the parents of that potential victim. There's no clarification as to exactly how that notification has to occur, but one would expect to be using, probably the old-fashioned telephone, or at least some other direct one-to-one contact. The third option is to notify the police, and I warn practitioners that in notifying the police, certainly you can call 911 if you think it is really an immediate threat, but if you call it a non-emergency number, be sure that you record who it is that you speak with, because calling a general number at the police department may result in getting lost, so that when something bad would happen, unfortunately, there would be no record that could be found that you had actually made that phone call. So it behooves the practitioner to record the information about who they called, when they called, and what they talked about. The fourth is if one takes actions to prevent harm while the police are summoned, you've met your obligation. It's not clear what this means because there are some things that you can't do as a provider. You may, for example, some of my clients work in large healthcare facilities. They kind of take a client for a walk around the facility until the police can arrive, the TDO can be prepared, whatever other steps may need to be taken. And last but not least, one has met their burden if they render therapy until the threat passes. Well, that is always open for second guessing, obviously, because these situations are only going to be looked at if there is a disaster. And so I always counsel clients, don't pick option number 4. But if you pick option 1, 2, or 3, or 4, you have met your obligation. Don't have to pick more than one, but I do counsel clients, it makes good sense to be picking more than one option in these situations. Because it may not be your legal obligation to take any more action. You may feel it to be your ethical obligation to take additional action. So what can't you do under this statute? The statute limits you to the actions that I've already described. You cannot detain the patient, so you can't lock them in a room until somebody else comes to help you. You can't duct tape them to your chair or something like that. There's no sort of citizen's arrest in Virginia. However, the statute does give you immunity for breaching confidentiality. So if you call the police, if you are communicating with a magistrate for a TDO or communicating with other providers, that is perfectly appropriate under this statute. Likewise, you are not held liable for failing to predict violent behavior in the absence of that explicit threat by the client to the provider. So even if you hear through the grapevine, even if you see something on Facebook, it doesn't create an obligation on the behavioral healthcare provider to be taking actions to protect a third party. And the provider has no obligation to take steps beyond those that are listed in the statute. So it's a very protective statute, cloaked in the mantle of saying there's a duty to protect in Virginia. It's very deceptive unless you read the fine print of what that statute actually says. So this is the statute that for patient privacy of their records in Virginia, and it says that in fact a healthcare entity may, or in other situations shall, disclose healthcare records as required related to serious threats by their clients. And so that gives us additional coverage to be breaching that confidentiality. It also goes specifically to the situation we just talked about, where we can communicate with third parties to protect that identified individual from additional harm. And last but not least is the opportunity for healthcare providers to communicate with threat assessment teams. Threat assessment teams are fairly unique to Virginia, but every school board district in Virginia must have a threat assessment team. Every public university in Virginia must have a threat assessment team, and private higher education institutions may have a threat assessment team. Most of them have elected to do so. These threat assessment teams are kind of beyond the scope of this conversation, but they were a direct result of the Virginia Tech massacre, where it was believed that the signs were there, but that it kind of fell through the cracks, and that the university was not well equipped to help address the problems that were available to be dealt with. I ran across this map that attempts to illustrate where the duty to protect or warn third parties lies in other states. It's not entirely accurate. For example, it says that Virginia is exactly like California, which is not the case. But it does point out, if you note the yellow states, being North Carolina being our closest neighbor here, there is no duty whatsoever to warn third parties or attempt to protect third parties in North Carolina. And that is consistent with the classic position of healthcare providers, and particularly of psychiatrists, that what is said in session stays in session, and that a psychologist has to take the confidences between them and a patient to their grave. Years ago, back in the 1960s, a psychiatrist, more than one psychiatrist, published their memoirs of their celebrity clients, and they lost their license to practice over it because it was considered unethical to be sharing those confidences with the public without the patient's permission. So where does HIPAA stand on disclosing information to third parties in order to protect that third party, or to get help in order to protect them? HIPAA says that in order to prevent or lessen a serious or imminent threat to a person or persons, a healthcare provider can disclose information to persons reasonably able to prevent or lessen the threat. And so obviously that would include police, law enforcement. It would include magistrates and other folks involved in the involuntary admission process. And it also includes the target, the identified victim. What can we do when we have a patient who's enrolled in a federally funded alcohol or substance abuse rehabilitation clinic, which falls under 42 CFR Part 2? You'll remember that there's a heightened confidentiality for these clinics historically. That is being somewhat rolled into the HIPAA standard these days, but there is still some heightened confidentiality there. It provides that, in fact, that threat can be communicated to those who can prevent or mitigate the injury, and to the intended victims. However, it does not allow you to identify the individual making the threat, which is somewhat absurd at times, because what are the police going to ask? They're going to want to know who it is that's making the threat, because that's the easiest way and most efficient way to try to protect that third party. So, where else does the duty to warn stay in place and is not affected by this nice protective statute that we've talked about already? Well, certainly the duty to report suspected child abuse remains, even with the duty to warn statute in Virginia, as does reporting elder abuse or abuse of the disabled. Both of those categories, child abuse and elder and disabled abuse, are two distinct categories, very heightened responsibilities to report by healthcare providers, and behavioral healthcare providers may not be on the medical side. Clearly a very important obligation by healthcare providers. And that wraps up our conversation about the duty to warn in Virginia.